Hi, I'm Phil Truitt of Truitt Law Offices, and I wanted to take a moment to talk with you about your upcoming deposition. A deposition is a statement taken of a party or a witness. This is taken in front of a court reporter. Any statements made may be used in court. It is one of the most important tools that lawyers use to gather evidence and information about a case. As a trial lawyer, almost every one of my clients who is involved in litigation will be required to give a deposition. And in some cases, I will depose the person who we contend is at fault for causing damages or injuries to my client. Here is some basic information about a deposition. In the deposition, there will be a court reporter whose job is to take down every single word that is said in the deposition. Sometimes the deposition may be videotaped by a videographer or recorded on Zoom. My clients will be asked a long series of questions by the attorney representing the opposing party. Lots of questions will be asked by the other attorney, and in some cases, there may be more than one attorney, and each will have their turn to ask questions. The testimony will be taken down by a court reporter who will type it all up and print it in a booklet-style form. To help you prepare for your depositions, here are a few things I always tell my clients. Rule number 1, tell the truth. This is the most basic rule and should never be taken lightly. Additionally, there are 4 steps that are important for you to understand. First, you should always listen to the question being asked to you very carefully. Listen carefully to the question, and then second, pause. Pause after the question is asked to you, and then pause before you answer. The reason you want to pause is 1, you want to make sure that the attorney is through asking the question, and 2, it gives yourself an opportunity to make sure you understand the question. And 3, it gives your attorney an opportunity to make an objection if one should be made. So do not answer the question too quickly and pause before you answer. After following these first 2 steps, then you can go on to number 3, answer just that question. Answer just the question that was asked. Then, number 4, stop talking. Stop talking after you have answered the question that was asked. Oftentimes, this is the most difficult part of the deposition because people want to explain all sorts of things in their answer, when quite often an explanation is not requested or needed. If an explanation is needed, typically the attorney will ask for it, or at the end of your deposition, your attorney may ask you to explain something further. So again, there are 4 steps. Listen to the question, pause, answer just that question, and then stop talking. By following these steps, you will be able to navigate an entire deposition very easily. A good analogy to deposition is that of a baseball game. In your deposition, you are on the defensive, meaning you cannot win your case when you are being deposed. However, you can lose your case. What I mean by this is when your team is in the outfield, it does not matter how good you are at playing baseball, you cannot score a run. I tell my clients that when you are being deposed, it is like being in the outfield. You do not have the ball, you will not be able to score a run. You are purely playing defense. And when I say defense, that means you must listen to the questions and answer them accurately without much elaboration. Then there's a time and place to elaborate on your answers, and I will get to that in a minute. Now that we've gone over these basic rules of how to procedurally listen, pause, answer, and then stop talking, the next important thing to know is what are the appropriate answers? What answers can I give? There are really just 5 basic answers that are key to a successful deposition. The first is yes, yes sir. The second is no, no sir. The third is I don't know. Number 4 is I don't fully understand your question. And number 5 is, if you need one, ask to take a break. These answers may seem too simple, but remember the old saying, keep it simple? Keep it simple applies to a deposition. If you know the answer is yes or no, then answer it that way. However, if you do not know the answer to a question, the worst thing you can do is guess. Don't guess at any answer. The problem with guessing in a deposition is that if you guess wrong, it might be interpreted as a false statement. We all know that no one is going to intentionally lie at a deposition, but by guessing wrong, you can cast doubt on your credibility. So if you're not certain of an answer, make sure you tell the attorney that you don't remember or you don't know or that you're not sure. If you are sure, then tell them the answer with certainty. A question I get asked often is, what if the other attorney asks a complex question, or it seems complex or compound with lots of parts? Please just ask the attorney to rephrase the question. The reason for this is that when your testimony is typed into a booklet, the question will be very clear and your answer will not be very clear. So if you did not fully understand the question and you guessed, then your answer may not be as accurate as you meant it to be. Remember, take your time. You are not rushed. As a witness, you get to set the pace by listening to the question carefully, pausing, and then answering the question when you are ready. Also, you're allowed to take breaks if and when you need them. A deposition is not an endurance test. Typically, most depositions come in 3 phases. Phase 1 will be about your life before the accident or the event that caused your injury. You will be asked all types of background questions. Common questions here are places you have lived, places you have worked, where you went to school, about all of your prior medical history, as well as the doctors you have seen forever in the past. Maybe if you've ever been convicted of a crime, been arrested, been in drug or alcohol rehabilitation, if you've ever been divorced, used an alias name, filed tax returns, or lied on an employment application. All of these are things you may be asked. You certainly will be asked if you've ever made any other claims for personal injury or workers' compensation. They will ask you to list all other prior injuries or hospitalizations you've had, and they may even ask you if you've been a victim of domestic violence or if you've ever been sued or sued someone else. They will ask you to explain how you selected the doctors you've seen for this case. They may also ask you if you've gone on any vacations or trips since the accident. In this background phase of your deposition, try to answer the questions without much elaboration. Keep it simple and straightforward. Phase 2 of the deposition is typically about the facts of the accident or the event that caused your injury. In some cases, such as a rear-end motor vehicle crash, the facts of the accident speak for themselves. You really won't have much to explain since you were facing forward, looking out the windshield of your car, and never saw that you were hit before the impact. In this situation, your answers will be short and simple. However, in other cases that are more complex and the issue of liability is contested or disputed, things are not so clear. In a contested litigation accident, you must meet with your attorney before your deposition. If you don't know how the accident happened or the details of it, then you may not be able to refute the defendant's version of the accident. You should discuss this type of information with your attorney so that you're able to easily explain the facts of your accident as you know them. Common tricks and traps to look out for. Oftentimes, attorneys will try to set a trap for you by getting you to estimate or take guesses. Estimations may hurt your case as to the amount of time or distance you had to observe the other vehicle. If you are able to accurately estimate those things, then please do so. But if you don't know, then do not guess. Make sure you and your attorney go over all the details of how the accident happened so that you are confident explaining what happened. In this third phase of the deposition, elaboration about how the injuries have affected your life are useful. You should elaborate thoroughly, explain how the accident has affected your life. Now you may be wondering, why is my attorney just sitting here quietly and not objecting to things such as relevance of the questions being asked? Well, while it's a bit frustrating for us as well, know that if your lawyers objected to all the things that they could object to in trial, depositions would take days and weeks rather than just a few hours. There's a rule of law that says lawyers can object to a few things in deposition. The first is your lawyer should object to anything that would violate or infringe upon your constitutional right not to incriminate yourself. We have all heard politicians asserting their Fifth Amendment privilege against self-incrimination. If and when your attorney makes an objection, it is best that you stop speaking immediately. Wait to hear what your attorney has to say and what he instructs you to do. Another common area of objection is one that calls for violating the attorney-client privilege. What you and your attorney discussed is privilege, and you should not answer. In other words, if the attorney is essentially asking you what you and your attorney have discussed, that is privileged information, and your attorney will object. Then your attorney will say that this is privileged communication and instruct you not to answer that question. These two objections are the main objections you might hear in your deposition, where your attorney will advise you not to answer. However, there's another objection which is called objecting to the form of the question. Your attorney may object occasionally to the form of a question being asked by the other lawyer. If your attorney objects to the form of the question, it is best to stop talking, listen to your attorney carefully, and he will probably tell you it is okay to answer the question, but there may be some technical thing about the line of questioning. It might be a compound question or a leading question, or there might be other things that are wrong with the question, and your attorney is just pointing it out for the record which could prove to be very important later on at trial. Here are a few additional tips to help you survive in your deposition. Do not ever argue with the other lawyer. If the deposition becomes unpleasant, it is your attorney's job to protect you. You should not have to fight for yourself. At times, the other attorney will attempt to inflame you just to see how you react. Next, avoid any attempt at a joke or sarcasm. This rarely reads well in a transcript and will make you look bad. Clients often ask, what if I make a mistake in my deposition? Do not become upset if you find that you've made one. Once you realize you've made a mistake, you should tell the opposing attorney that you made a mistake and would like to correct or clarify something you said earlier. Also, if you were asked to produce a document such as a diary, journal, notes, driver's license, health insurance, do not agree to show or give it, and ask that they speak with your attorney. Another thing that happens often is, what if the other lawyer interrupts me? If you were interrupted by the other lawyer, stop talking, let the other lawyer finish speaking, and then courteously state that you were interrupted and that you did not finish answering your previous question. What if they ask me the same question over and over? Some lawyers will ask the same questions over and over, slightly differently, and the reason for this is that they are trying and hoping you change your answer. If this happens, the best thing to do is politely remind the other attorney that you've answered that question before and your answer is the same. One other thing to remember is that the opposing lawyer is not your friend. This is not a friendly, casual conversation. This is an interrogation. The other lawyer has a job to do, and it is to find holes and weaknesses in your case. It is not your job to help the other lawyer if they don't seem to be understanding something. You have the right to make them ask the right questions. If they can't or don't ask the right questions, you don't have to help them. Another tip is that a deposition is not a memory test. Some clients ask, what if I can't remember all the dates and locations? That's okay. Do your best, but never give a firm answer if it is a guess. Rather state that you do not know exactly. These are just a few basic guidelines to help you understand the process of deposition. The preparation for a deposition can be a few hours or in some cases a few days. Generally, you will get a call with your attorney the day before the deposition to clear up any concerns you may have. I'm Phil Truitt of Truitt Law Offices, and we appreciate you trusting us with your case. We will do the best to make sure you are prepared and not stressed for your deposition. It's going to go great.